a second around what that looks like and how that works. 76% of experts believe that the benefits outweigh the risk. And I think we're certainly in that bucket as well. I think there is definitely some things we need to think about, as with all new technology, but really trying to drive in and leverage it is certainly going to be very, I guess, optimistic for how we see the market moving forward. 60% of the world's population lives in a jurisdiction covered by AI. So again, we'll touch on this. Paul will talk a little bit more about that. One of the things I did find interesting is some of our legislation is really coming in, September 2024, and looking at some of the Chinese legislation from China that kind of kicked off in 2016. So certainly some companies or some countries doing it a lot more than others, but interesting way of things we need to dive into today. 54% of us will use some AI to make consumer decisions. Again, something we'll touch on again in a minute, but around hallucinations and maybe not necessarily, unless you have the right answers, knowing that the answer is correct that's been presented. It's something I know I've faced, and I think a lot of us will maybe on the call. 35% of parents discuss AI with kids, although this increases significantly among groups with higher levels of education. So really talking to your kids and getting them on board early is certainly something that we do definitely recommend and obviously want to see. But enough with the fun facts. Let's jump into some of the cyber threats and I guess what we're seeing in the market. So on screen now, you can see a report that I found from February 2025. Now, this is specifically about healthcare. If you want to dig into the full healthcare report, I recently presented to a whole heap of hospitals in South Australia. So I took this from here. But the reason I put it on the slide today is that I think it's fairly representative of what we're seeing in the market at the moment, not just with healthcare, but across the board. And so some of the things that they found with their studies in regards to healthcare is the threats in 2024 versus 2025. And again, that's very representative. So number one being ransomware. 2 is phishing. So obviously trying to compromise your credentials. 3 is leveraging those compromised credentials. 4, third-party credentials, so working, obviously getting third parties involved and trying to attack through the third parties. And obviously number 5 being data breaches. The way that's changed a little bit, and this is something that we'll touch on a little bit more detail in a minute, but ransomware deployment, so obviously ransomware is still number 1. We've really seen that come back with a vengeance. That is certainly happening in South Australia and happening right now. Third-party data breaches obviously leading to compromises. Again, that's really been on the rise. We're seeing that a lot more over the last few months especially, but we're expecting more of that. Obviously, internal data breaches, people either accidentally doing a data breach or, I guess, third parties getting in to get your data. Supply chain attacks, which is something the government's very hot on, making sure you understand your supply chain and how that works. So, attacking throughout the supply chain is something that's a big issue and needs a lot of work to address. And then what they call zero-day exploits. So those exploits that pop up out of nowhere. Unfortunately, AI is used for good and bad. And one of the bad things is that they can generate these attacks very rapidly and then release them to the world very rapidly. So having no time to work out how to prevent a breach is becoming more and more of an issue. It used to be back in the day where you used to take a week from something coming out to being live, and now it's seconds. So how do we kind of work through that and prevent that? Being I'm doing a lot of talking, how about I hand over a little bit to Paul if you want to jump in and talk to us about what you're seeing around the node.
Yeah, absolutely. And look, I think that what you've just gone through is mirrored in what we're seeing from a privacy perspective, because the two things are very much linked. When you have a breach of any kind into your cyber systems, it invariably involves a privacy breach, and it often will require a report. And so if you have a look at what the Information Commissioner has put out there as being the general causes of mandatory data breach reporting, we can see that a significant amount of it is coming from malicious actors. We used to see that diagram, I think, on the right there. Human error used to be a much bigger contributor to data breaches happening, and that's the one which I would guarantee every single business listening to the call today has had someone who sent an email to the wrong address. It happens. And it's one of those things that is very difficult to solve for. But a vast majority now are these malicious actors, and in particular, ransomware attacks. And the sectors that they are hitting, if you are in any way involved with healthcare, be it a healthcare provider or a related entity, you are a massive target. Some of my clients who've gone through these things have been charities in particular. So we've had real, and it's just, not only are ransomware attacks just awful, but they're just morally repugnant when you're going after a charity. But it's what happens. People look to see who has the most sensitive types of information stored, who will probably not have the resources to properly safeguard themselves because they're not a massive entity, and they target them because they are vulnerable. And so we are seeing this happen more and more as the cause where we are unfortunately having to get involved to deal with privacy law breaches arising from third-party acts.
Absolutely. I think we can echo the same thing. If we dig into a little bit more detail, so this is again something I shared with the hospitals that we talked to recently in South Australia, but these are examples of really what we're seeing. So back in the day, one of the things that used to happen often was around cryptoing the environment, so that you basically got that big red screen, someone has to make a phone call and hopefully release the data, in which case people obviously get paid. That's not been enough of a deterrent, and people are more willing to go back to backups or go back to something else. So what we're starting to see a lot more, and we saw this in the Medibank breach obviously a little while ago now, is once they exfiltrate the data, they take the data, then they encrypt it, then they can call you up and say, hey, by the way, we've got your data. Your data is probably next to useless to you now locally, but the thing that most people are really worried about is them releasing that data. So again, why healthcare is very important, because obviously they have a lot more private information being stored. And so in the case in June 10th around Epworth Healthcare, obviously they managed to get 40 gigabytes of data, which is obviously a massive pool of data. But that's kind of then where they start leveraging it and say, well, effectively, if you don't pay us, we're going to release this data to the public. Which again, this is exactly what happened in the Medibank scandal. And so they had things like database logs and hospital booking forms and payroll and medical imaging files, these type of things that you really definitely don't want to see out. And once they're out, unfortunately, they're out. A couple of days before that, there was a couple of Victorian entities that had exactly the same problem. And they actually went to the next step of publishing stuff to their website and basically took over their website saying how many hours they've got left before publishing this data to the public. And so this is kind of really where it gets very messy and obviously very public. So whether you're in healthcare or whether you're in any industry, each of us has got our own information that's probably more sensitive than others. And so being able to obviously protect the data is number one, but obviously having a plan of attack, what to do if you do eventually get breached, is also pretty high on the list of things that we need to really talk about a lot more.
And it's not just in healthcare. I mean, we had an example in the legal industry where a significant national firm I think it was probably 18 months ago, were the subject of exactly this kind of attack. And when it hit, they had the question to ask themselves, do we pay the ransom? Because they had legally privileged documents about hundreds of thousands of cases that the bad actors were threatening to publish. They published little excerpts to prove that they had the information, that they were able to do it. And that firm, to their credit, stood firm and said, no, we are not going to pay this ransom. But when it happens, when you get hit with ransomware, you need to be very mindful of the various obligations that arise. One of the things which I was asked probably about 2 years ago now when a client got hit by ransomware is whether or not it actually was a privacy breach for someone to have come in and encrypted your system. Because the client was saying, well, we don't know if they actually took anything out. We just know that they came into the system and they encrypted everything. So there's not been a privacy breach. No one else has the information. But in reality, to be able to get into your system, they have already gotten to the point where they can see what is in there. They can see the files, and unless you can definitively prove that the malicious actor hasn't looked around when they were in there, you can't hand on heart say that no information was disclosed to a third party. And so because of that, if you are the victim of a ransomware attack of any kind, you have obligations to make reports. Now, those obligations only kick in for certain organizations or people. Firstly, if you have a turnover of $3 million a year or more, and if you're in the first year of your operation, you pro-rata that to see how much of the year you've had and how much you've earned, then you have an obligation to report it to the Privacy Commissioner, but you also have an obligation to report it to the Department of State and the Australian Signals Directorate. If you are in healthcare, and that includes fitness for some reason, because I guess fitness is a kind of healthcare, you also have an obligation, regardless of your turnover, to report it to the Privacy Commissioner. And if you operate critical infrastructure assets, which is a super broad definition, like covers critical educational assets, critical hospitals, critical food and grocery assets, then you have an obligation to report that to the Department of State and the Australian Signals Directorate, regardless of your turnover. And what all of that means is that basically, if you have been hit by a ransomware attack, you should be getting legal advice. It doesn't have to be from me, but you should be getting legal advice, because if you fail to comply with these obligations, not only are you dealing with a cyber incident, you're also then potentially dealing with a breach of law and significant penalties that could be in the hundreds of thousands of dollars. So you don't want to be hit with a double whammy of not only dealing with the actual incident, but then having the government after you for not having reported it appropriately. The other thing to consider is what your liability is going to be from your clients, from anyone whose information you hold. Because we'll go to later in the presentation, there are now obligations and rights that people have against you for breaches of privacy that could apply. And so if you are found not to have properly secured your systems by talking to some very well-credentialed IT service providers like Subnet, then you might be deemed to be negligent for allowing information to have been exfiltrated. And that can have another impact as well. So we can't prevent data breaches from occurring. We can't prevent cyber risk from being there. But what we can do is take every reasonable measure within the context of our business, within the context of our size and capacity to take those measures. And by doing that, we create a defensible position if any of these things happen to occur. And that's why part of your legal strategy, when I'm talking to clients, is what is your security strategy? Because if you haven't done that, then when it comes to trying to defend you, my job is much harder. It's going to cost you a lot more in the long run.
Absolutely, both probably from a breach and also from post-breach cleanup. I think that's what we're seeing now also when it comes to insurance. Like we've really seen over the last probably 6 to 9 months, insurance companies moving from a position of tell me all the things you're doing to protect your data to realizing that at some point your data's probably going to be breached. And so we're seeing a lot more of the conversation turn to, okay, so once you're breached, what's your strategy? What's your plan in place to minimize the impact, to obviously be able to tell the right people when they need to be told, and obviously have a plan of attack on how you're going to deal with it. So we are seeing a lot of that coming forward. Paul, I don't know if you've also had any information coming through from the legal side. I guess what we're hearing from a cyber side and the Australian Signals Directorate is there's going to be a lot more push on both, like you talked about, their critical infrastructure. So if you're classed as critical infrastructure, needing to have more I guess, governance in place. So whether that's ISO level accreditation or some level of accreditation, and also the fact that they're talking now about having to publish and tell people if you've paid a ransomware attack. So they're probably two big things that we're hearing coming. I don't think it's out at the moment, but Paul, have you heard anything about any of that?
Well, in terms of the obligation to inform about whether you've made a payment, that absolutely is in place. And so if you have made a payment and you are in one of these categories, you have an obligation to inform the Department of State and the ASD. Right. So that is an absolute obligation that happens right now for these court organizations. What we are also seeing from a contractual perspective is a lot more obligations, particularly for government, people doing work for government, is to have in place a business continuity plan that properly addresses the issues that arise from a cyber breach.
Definitely, absolutely. And obviously what we're talking about, John Paul, Ben?
Yeah. Sorry, Brett. I actually just got a few questions that have already come in already, actually, before we move on to the next slide, if we don't mind just going on a bit of a tangent here. We just had one question come in about data breach reporting. We're just going to bring it up on the stage. Paul, you might have an input into this one here about reporting beyond the OAIC. Is this part of the new legislation, or was that something that has already existed in the legislation?
So this is actually not in the Privacy Act. This is in the Cyber I'm going to lose the name of the act. It's the Cyber Response Act, effectively, which is a separate piece of legislation that came out of the Department of State about 6 months ago. So that is a new and additional obligation that has come through that is similar but different. So you now have 2 places that you need to report to.
Thank you very much, Paul. And just removing this question from stage, because we just had another one as well regarding the responsibility of third parties, including managed services providers, for example, if a customer fails to self-report in the event of a breach. Paul, any ideas as to the responsibilities that a managed service provider or another third party would have in that instance?
Absolutely. So the obligation on a party when information has been breached is to firstly make reasonable inquiry of whomever was the prime victim, I guess. So what you'd be looking at there is, let's say a customer was the subject of the data breach. If the managed service provider is aware of it, they have an obligation to say to their customer, are you making a report? Or are you investigating? If the customer says we are investigating, that is absolutely fine. Then you don't have to do anything, but you do need to check in after the 28-day period and say, what did you find? Are you reporting? If you are not satisfied that the outcome of their investigation is accurate, or that if you are not satisfied that they are going to do the right thing and report, then your obligation to report kicks in. So you don't have to double up, but you do have to report if you are not convinced, acting reasonably, that they have done a full investigation and are reporting where necessary.
Fantastic. Thank you very much for confirming those details, Paul. What I'll do is I'll just remove that question from the stage there, and I'll bring our presentation back up onto the screen.
Great
Fantastic.
questions.
And
Obviously, keep them coming in.
Yeah, please, by all means, keep those questions coming in, because again, we're more than happy to answer them as we go along. But in the meantime, I think, Brett, I'll hand back over to you, and I'll just remove myself again.
No worries. So one of the things I was just going to touch on is around, obviously we've talked a lot about ransomware, and that is definitely the prevailing force that we are seeing a lot more of. And again, this is happening across South Australia and across Australia. It's not just obviously healthcare. We are definitely seeing it from multiple different manufacturing. We've talked to people recently. Obviously, we saw a report recently of legal teams having the same issue. So definitely very prevalent. But obviously, there is more than just ransomware attacks. One of the other things that we're starting to see a lot more of and is coming to market is around things like AI and deepfake attacks. This is the one I pulled up from a Financial Times report around the UK engineering firm Arup. Lost about 200 million after fraudsters digitally cloned a version of their senior manager to order financial transfers during a video conference. So not only do we have to worry about people getting an email coming through, you also need to be very conscious that even now seeing people is not necessarily enough to verify what that is. We've heard this certainly in the past around even parents getting phone calls from their kids, and it ends up not really being their kids. So using deep fake is certainly something that is being easier and easier to generate, and it sounds more and more legitimate, kind of like that first bullet point. But using AI, not only do the good guys have AI, the bad guys obviously have AI to leverage as well. So we're starting to see a lot less of those really badly worded, poorly grammar checked, poorly spell checked emails. They're now looking more and more legitimate because obviously they're running that through an AI bot to actually come back with a very coherent, well worded, tokenized to Australia version of an email. And so it's getting harder and harder to detect whether those are real. But equally, as I said, really seeing that jumping down to the next step of you can't necessarily trust a phone call or necessarily trust a video call. We are seeing, obviously, a lot of parties. The one that is on the right here is around one of the things that Microsoft's doing using AI video detection. So starting to try and detect if this is an AI-generated image in the background and obviously flagging that. But even just down to very simple things, this is a brand new tactic that we saw came through. And this is literally an email that I had last week that we hadn't seen previously. And now we've seen this in multiple clients because obviously we get to see a wide swath. They're actually sending you calendar appointments from yourself. So you see something pop up in your calendar because it bypasses a lot of the ways that we see things. You don't necessarily see the email. And then suddenly you get a calendar reminder, hey, you've got to do this thing. So in this case, it was a final notice mandatory employee acknowledgement required, obviously just after the end of financial year, and we do things. And so this popped up in my own personal calendar with a nice link there for a HR package that we needed to approve. So this could have been one of my team leads passing it on to me. And so they're trying to be very smart about how they're bypassing the traditional ways that we've seen people come in and trying to attack your data. So real world effect.
But Brett, just to interrupt there as well, we just had another question come in as well. I'll just bring it back up onto the stage here. Just give me 1 second. So, Paul, it's just something you mentioned earlier about if a malicious actor has already had access to your system, then you probably would have an obligation to report. So the question is about if it is a single account that gets phished, that account has access to corporate data, and what is the obligation to report there? And if I may, I've received a follow-up question as well to that one as well about if in the instance it's only personally identifiable information, is that when the reporting is required, or are there other circumstances where that mandatory reporting would be required?
So this comes down to the circumstance of each particular case, because what you would have to assess is there a likelihood that the breach has caused or could cause a person serious harm? That serious harm is beyond just emotional upset, but actual serious harm, although emotional upset can get to a level of being serious harm. If the account has information which is all publicly available that someone could have found by Googling, then no, you don't need to make a report. But if it does contain information about an individual that could cause harm, then that would be sufficient. And we often have to make assessments such as, what is the fortitude of the individual? I've had a situation where there's been pretty mundane information breached, but because we knew this was a very highly strung person whose information was exfiltrated, we needed to make a report, because when we told them, like the mere fact of telling them about the breach was, we knew, going to cause them significant distress. And so we had to make the report because that was the situation. So it will depend upon the nature of the information, the nature of how it's been breached, where it's gone to, etc., and the individual whose information has been lost. So it's unfortunately not a one-size-fits-all. If you ended up paying a ransom in relation to that phishing, which wouldn't be right for a phishing account, but anyway, then you'd have to report that. But otherwise, so the reports to ASD and Department of State is really when you've paid a ransom. It doesn't necessarily apply to every other breach. So that wouldn't probably arise in this instance, but the OAIC reporting absolutely would.
Fantastic. Thanks for confirming that, Paul. Again, I'll just remove that question from the stage, and I'll bring our presentation back up online as well. And Brett, I think I'll hand back over to you.
All right. Well, keeping on the thing. So one of the things, Paul, you raised was just around how you do the wargame attacks and what does that look like?
Yeah, so it's one of the things which a colleague of mine raised with me probably about 9 months ago. I think it's such an important thing to do. We've been doing it here internally, and we recommend our clients do it as well. It is one thing to have a view of saying, well, I just never would pay a ransom, or of course I pay a ransom. Until you are in the instance of actually dealing with it, it is difficult to know how or what you would do and react with when that happens to you. But the best way that you can prepare for that is to wargame it. And so we look at the questions like, who's in the room when the ransomware attack comes in? You want to make sure, I would suggest that you have your IT people, obviously. You also probably want to get your lawyer in the room. You might be looking at, what about your crisis communications people? Who is going to be dealing with the advertiser when they come knocking on the door saying you've had this breach? How are you going to marshal those people? Who is calling whom? How quickly can you get it together? What about your insurance broker? Do you have cyber insurance? Then the question comes, can we pay a ransom? There's a question of should we, that's one thing. But if you are doing contracts for government, you might have clauses in your contract that say you are not allowed to pay a ransom. What kind of currency are they asking you to pay in? Because different types of crypto have different levels of risk associated with them. What are you going to be able to live with in terms of an amount if you decide to pay it? So to give you the example, HWL Ebsworth, which is the firm who was breached, they've been great. They've been talking about their experiences quite publicly now. And they said that it would have cost them a fraction of the actual cost that they have now suffered had they paid the ransom. The ransom demand was a pittance compared to the amount they've actually lost because of lost clients, cost of remediation, the amount of work they have to do to recreate their files from historical backup, etc. But they weren't able to pay the ransom, I think, if they wanted to, because of the number of government contracts that they had. If you are going to pay that ransom, pressure test yourself. I wouldn't pay a cent more than $100,000. Okay, what if it was 101, 102? You have to test yourself. And whilst you might change your view in the moment, you might alter your position, if you've at least had a time when you wrote down on a piece of paper to say, objectively, in the cold light of day when I don't have any pressure on me, this is what my plan was, it gives you something to hold yourself against when you are under that pressure.
Yeah, one of the things I was just, sorry, before you jump in, Ben, one of the things I was just going to say is that's definitely something that we see as well, because not only are you thinking about what you would do in that, but also having that conversation, as Paul said, with the rest of the group, because what you're going to do and necessarily what the rest of the people that come in during that discussion, what the board might do, what the executive might want to do, may be very different things. And doing that live when you are actually cryptoed or you are actually under threat of having your data leaked is definitely not the time to do that. You really need to have these conversations, and you need to have them ongoing and test different methodologies. One of the things that was kind of really interesting to us was around, we talk about some of this testing on cyber events. It should be done across all levels of business and all different things. We send people interstate or overseas. What happens if that overseas location end up having some sort of terrorist act or some sort of war that break out? What's your process when that goes through? So actually theory crafting this out, having tabletop exercises is really critical. And it's certainly one thing that we'll touch on in a little bit around our managed service. We actually strongly recommend having incident response plan testing so that you can actually run through that process and say, okay, Fred's been crypto locked. Now what are you going to do? And actually test all different aspects, because what you'll find is things come out of the woodwork that you wouldn't have even thought would have happened. But unless you've run through that process a couple of times, you may not even be thinking the right things, and your incident response plan may not have the right information in there to be able to make those calls. Ben.
Yeah, thank you, Brett. Paul, I've just got another question that's come in as well. And actually just goes back to that discussion we had around about third-party obligations. So do you mind just providing a little bit more clarification around the obligations for a third party? For example, the investigation outcome is unsatisfactory. Any insights you can provide on that one, please?
Yeah, so I think what you'd have to do is you can't assume that you know precisely what the other side has done. They might tell you that they made a report, but you don't believe them, etc. There's never a harm in my default position is, if in doubt, report. Particularly in the situation where you are not the prime victim, you have very little to lose other than potentially a relationship with the victim by reporting, because you effectively would be doing a report saying, we are filing this report for the avoidance of doubt. We think that the other side that the other party's done it, or we're not sure if the other party's done it, but we just want to be clear. We are aware of this having occurred. We believe, based on the information that we have available to us, that it should have been reported. And so and I would always frame it in the way to say, I would never say the other party hasn't reported it and they should have. I would always frame it to say, we don't know if the other party has reported it, but in case they haven't, we're providing you with this report because we think it's appropriate to do so. I think that is the safest way to proceed. Then there are always going to be relationship reasons why you might not want to do that, and you need to consider how confident you are as to whether or not a report is actually required before you do this. But it is certainly something that I would look to do, and I would, as I say, I would never say they've done an unsatisfactory investigation. I'd say we're aware of this. We're not sure of the full details of what's happened, and just in case, we thought you should know.
Fantastic. Thanks for clarifying that, Paul. I'll just bring the presentation back up on the screen again. Excellent. And Brett, I think I'll hand back over to you again.
No worries. So yeah, one of the other things I was just going to touch on, which we kind of brought up a little bit earlier, is around people being in your network. I think what we've found is on average, it's about 44 days that someone's in the network before they do the ransomware, before they do the thing. Because obviously they're trying to do things like turning off your backup checks or turning off a whole range of different things to get access to more accounts. And they don't want to alert you to that fact unless it gets to the point where they need to. So yeah, quite often it's a large period of time that they can be in your environment before you even know, unless you have a lot of tools set up to make sure you're at least detecting it.
So, and it's one of those things where, in the example I was talking about previously, where we were trying to decide whether or not we had to report, we could see that you're right, they've been in the system for probably a good month, and we couldn't see huge amounts of information going out, but we couldn't discount the fact that they were at least viewing the material. And that is enough to be a problem.
Definitely an issue. Okay, talked a lot about cyber. How about we jump over to a new topic with privacy, obviously related, but something that all businesses are really going to be impacted by, certainly with the new tranche of legislation that's coming out. But yeah, maybe if we want to touch on that. But first, a couple of other fun facts. Okay, let's try to keep this a little bit smaller. 23 gigawatts of electricity will be burned to power AI in 2025. It's one of the unseen facts and one of the unseen costs that we're seeing, I guess, a lot more in the background. I did like that. There is 19 time traveling DeLoreans could be powered up with a 1.21 gigawatts, but half a liter of water is used to cool data center servers on the average ChatGPT session. So me developing that AI image down the bottom there took me 3 goes. And so, yeah, probably chewed up a couple of liters of water than that. And 1.7 gigatons of additional CO2, obviously all those that we're trying to do the green thing, being generated by AI between 2025 and 2030, according to the IMF. So massive amounts of work needs to be done in both trying to develop power, but also having clean power and having clean energy is going to be something that's going to be critical with more and more AI being used. But yeah, enough about that.
I was concerned. I heard that the current theory is to just basically dunk whole sealed data centers into the ocean.
Yeah.
Which less CO2, but also doesn't that warm global water temperature?
Yeah, might be an issue for something else. Maybe, Paul, just want to talk about a little bit of stuff of what we're seeing in privacy in Australia.
So, look, for those who aren't across the Privacy Law Act, this is for you. For those who are, I apologise for a bit of 101. But basically, we don't have a generalised right to privacy in Australia, which is quite different from other countries. Instead, we have a legislative or statutory regime. So we've got a piece of law called the Privacy Act that applies to some, but not all, organisations and businesses. And it's aimed at protecting personal information, which is information or an opinion, whether true or not, whether recorded in material form, about an individual who has identity as apparent or can be reasonably ascertained from the information or opinion, which basically means anything from which I can identify you is personal information. Could be a license plate, could be your image, could be your voice, could be your name. And the Privacy Act kicks in for businesses with a turnover of $3 million a year or more, health and medical operators, or those selling or trading in data. And one interesting thing that people often don't realize is that last one kicks in if you want to sell your business. So you might not be caught by the Privacy Act, but then you decide that you're going to sell your business, and that includes a client list. Guess what? Suddenly you're caught by the Privacy Act, and you need to go through and do all those privacy compliance things you were able to avoid for so long. Now, the Privacy Act has been around since 1988, but it only really was given teeth back in 2014, when there was a significant reform that introduced obligations under what are now known as the Australian Privacy Principles, which used to be the National Privacy Principles. And they introduced really what I would call an obligation to inform. You didn't really need to get people's consent for much, but you need to tell them what you're doing and why and how. What we've now seen this year is, after a 5-year review, the government has started to introduce a bunch of new measures. And they're doing this in tranches. They've announced things which they've accepted entirely. And the first of those has now been brought in as of 1 July this year. And others which they've agreed to in principle. And so we're going to see them after, theoretically, a level of consultation. And the changes that have come in are probably on the lower end, other than one, of what we're expecting to see. The upcoming changes are going to have massive impacts on how we do business. So the first tranche are the ones that you've got there. So the OAIC, Office of Information Commissioner, and the Privacy Commissioner have been given new penalty powers. And interestingly, they've been given some smaller penalty powers. So these are fines in the tens of thousands instead of hundreds of thousands or millions. And what that says to me, together with their extra resourcing, is that we're likely to see more low-level enforcement action against smaller businesses than we've seen already. Because up until this point, there have not been a huge number of prosecutions for privacy breaches in Australia. The Privacy Commissioner announced that they're going to be taking action against Optus for their most recent data breach. But we haven't seen too many of those types of things. But what we are now seeing in our interactions with the Privacy Commissioner is that whereas previously it was a situation of you put in a breach report, you get something back saying, thanks for letting us know, do better. And that was pretty much the end of the conversation. Now we are having much more back and forth with the Privacy Commissioner staff asking questions about, well, what was your system in place to prevent this from happening? And why did you do this or that? And how was your investigation conducted? And did it do the appropriate things? And why did you tell this person but not that person? It's getting into a lot more granular detail before we're getting to a conclusion with those data breach reports. And because of that, I think we can honestly say we're moving from the educational campaign to the enforcement campaign. The other thing that has come in that is really important to be aware of is that prior to 1 July, the only person who could sue you for a breach of privacy was the Privacy Commissioner. Now, there is a new tort of serious invasion of privacy, which means that any individual can take action against you for intruding upon an expectation of seclusion, which is some fun words the legislation uses, which basically means that whilst it was previously lawful for me to stand in the middle of a public road and take a photo through your window into your bedroom, creepy but legal, that is now likely a breach of someone's privacy. Similarly, if someone else does something which seriously breaches your privacy in general, it's less defined, a person, you can sue that organization or individual for having done that. Now, it still needs to cause serious harm. And we are yet to have much case law, if any, about what this is all going to mean. But just because someone might fail when they sue you doesn't mean that it's going to be a pleasant experience for you defending that. And what I foresee we're going to end up with is a bunch of low-level, annoying privacy tort claims against businesses when data breaches occur. So it's really important that you be aware that that is now an issue, and that can inform how you manage data breaches. And that's why that PR piece can be as important as your cyber or legal response. Because if people are upset with you, that's when they're going to potentially sue. We've also seen some other interesting ones, which are possibly less relevant now. So one of the things that can happen now is that the minister is able to whitelist an area overseas and say, we are comfortable that this place is safe for personal information to be sent. And therefore your risks in having offshore data processing are decreased. Nowhere has been whitelisted yet, but I would imagine potentially the EU, where they have stronger data protection laws than we have here in Australia, maybe California, potentially Singapore, and New Zealand are all places that might well be whitelisted in the future, which would mean using offshore services in those jurisdictions might be less risky. There is also now an ability to declare a data breach by the minister, which would basically say that anyone who has information from a data breach cannot do anything with it without breaching the law. And that was designed with what happened to HWL Ebsworth, because when they were the subject of a data breach, they went to court to sue the world because they didn't know who'd done the breach. And they said, anyone who uses or discloses our information should be in breach of the law. And the court granted that order. So this is kind of the legislation allowing the government to do that without having to go to a court. The other things that we're seeing is there's now a criminal offence of doxing, so you can't inappropriately reveal a person's identity online without their consent. They are consulting about the creation of a children's privacy code. So if your business deals with children's information, you may have to be aware of what comes out of that. And a really important one for the next topic that we're going to discuss in terms of AI is that you need to disclose in your privacy statement how automated decisions are made when they affect people's rights. So if you are using ChatGPT to sort through CVs to determine which ones you should shortlist for an interview, your privacy statement now needs to say that we are using OpenAI's product. Here's an explanation that OpenAI provides as to how their system works, and this is how we are using it in our organization. I've just noticed briefly what that question is, so I might just say this next one before we go to that one, Ben. And that is, this is now moving into things that haven't yet been introduced. The Tranche 2 privacy reforms, which are promised at some point in the near future, we don't know when, are going to include a right to be forgotten. So in effect, you will be able to say to a business, I do not wish you to hold information that identifies me. And that is already in place in Europe under the GDPR, which is the General Data Protection Regulation that is the European equivalent of our Privacy Act. And it makes it really difficult when you have things like historical backups, because are you going to go through and load those up, delete them, and resave them? It is quite an interesting thing to deal with. But it is also something that, even though that hasn't come in yet, does apply to any business that holds sensitive information. So sensitive information is things like medical records, genetic information, details about someone's religion, ethnicity, sexuality, political affiliations, membership of trade unions, criminal history, etc. If you hold any of that information, a person whose information that is has a right to require you to delete it. And unless you have a legal basis to continue to hold it, you must comply with that. So whilst everyone has been a bit up in arms about how this is going to change the face of how we do things, technically, it sort of exists already in the sense of sensitive information.
Thank you, Paul. Just to interrupt there again, because I think you may have already alluded to the answer to this question anyway, but I'm going to bring up on stage anyway, just in terms of the employee records exemption. So in terms of why an organisation are keeping former employee records, are you able just to clarify that point again, just for the audience there, please?
Absolutely. So this is one of the new ones that is going to come in, and they are consulting to see how this is going to work. At the moment, any records about a current or former employee are exempt from the Privacy Act, which means you can do what you like with it, effectively. You don't need to say what you're doing with it. You don't need to say why you're keeping it. You don't need to have any purpose for holding on to it. And that includes sensitive information about employees as well. If the employee records exemption is removed, it will mean that employee records must be treated in the same way as every other bit of information you have. And that means that there is an obligation, when you no longer have a legitimate purpose to hold the information, to delete it. And so, yes, Yanni, that is correct. If you don't have a basis for holding on to that information, you should be deleting it. But I would say that the same principle applies in relation to all of your information, that just from a data hygiene perspective, you don't want to be holding on to stuff longer than you need to. And from a legal basis, with some limited exceptions, I would normally say that if something is more than 7 years old, or you've no longer had that employee for 7 years, legally, you don't have a reason to hold on to it, because the statute of limitations for pretty much all different kinds of civil actions is 6 years. So it's different with deeds, that's 12 years. As I said, there are exceptions here, but generally the position would be, if you've gone past 7 years, it is unlikely that you would have legal cause to have to rely upon those records. And so unless you have another good reason for holding on to it, I would be deleting that information unless you can explain why you want it.
Fantastic. Thanks for clarifying that one, Paul. Just remove that from the stage and bring our presentation back up again.
Yeah, I was going to say, we're going to touch on that in a second in the next slide as well, because obviously there's the with tranche 2, obviously it's not in place yet, but it's certainly something that you do need to start thinking about now, because to implement this is not going to be trivial. One of the things we touched on the next page is just kind of, I guess, around the similar type of thing, is that right to delete. So if there is some level of, hey, you need to remove me from your systems, again, how do you actually do that physically? And some of the answers aren't easily, I guess, understood right now from a technology standpoint. So obviously we know that we need to keep what we would call immutable backups, so backups that can't be touched, so you know they're legitimate. You can't just delete something really nearly out of it. But if you then have the corresponding thing of, hey, I should lose this data, you don't want to end up in a spot like Optus, where they had medical information that they did as part of their citing process very early on, but they still retained it post needing it. And so how do you then go through and remove that, obviously, from your systems? Because that's one of the things that we touched on in this section is, it's easy to talk about, but then how do you do that? So some vendors are doing things like being able to overwrite the ability to restore the information from the tape. So the tape or the immutable backup is still retained, but you can't actually delete. So you can't actually recover any of those files that you've listed as being able to be deleted or should have been deleted. So there are ways we're working through that, but it's not a simple process. The other thing, as we touched on with the Medibank breach and with the Optus breach, having too much information about individuals where you don't necessarily need it moving forward is really great. And something that we should obviously be doing in our systems, but most don't. So asking yourself the questions, should this just be cited? So one of the things we do, for instance, with doing police checks, which we require of all our staff, or doing things like our early childhood screening checks and things like that. So we cite it, but we don't actually store the information. And obviously we leave that with the individual that can own it and have it. It means we've got one less risk about actually maintaining a document, and if we get breached, having that data out there. But also, we don't need to have it once we've cited it. Obviously, we continually cite it. So how does that work? Thinking about things like having automatic data deletion policies, again, going back to your SharePoint or your document libraries. Do you still have 20-year-old documents? Purely not because you're specifically going back and looking at it, but is that data still there? And should that data still be there? Do you still need it? And therefore, should there be a way of actually removing this after a period of time? Maybe it's that 7 years that we talked about, or longer if there's specific requirements. And then getting to the technical nature again, will your systems actually allow you to remove that? Those lovely little stars next to fields on particular applications saying this is mandatory. Do your systems actually allow you to remove those? So starting to look into those and working with providers to be able to say, is this coming on your roadmap? Is this something that's going to change so that we can actually remove this information? Because if this has to stay there, that may be contravening some other law or legislation that is coming up. Certainly a lot to think about.
It is. It's one of those things where I always find it a little bit perverse that effectively what we're seeing in Europe as the position is, we'll have a list of names, and when we do a backup, we will ensure that once it's restored, we will immediately delete everything from those names. So that means you're actually still storing information about the person who asked you to forget them so that you can remember to forget them, which I do think is a little bit perverse, but it's the best I think we have at the moment. And what you've described there is exactly what we need to be looking at as to how you manage the conflicting obligations to have that immutable backup with these new rights to be forgotten.
Yeah, it's going to be tough over time.
One thing I'll just mention on the previous slide, just for anyone who isn't caught by the Privacy Act, that small business exemption is going to be removed as part of the tranche 2. Again, we don't know when that's going to be. They have yet to start consultation, so I would say at least 12 to 18 months away. But just be aware, if you think, oh no, this applies to me, that's right for now, but it will apply to you in the medium term, I'd say.
Yeah. Plan that's going to apply and then hopefully work it out. Now, I know we do only have a little bit of time left. We obviously, from my side, I can go a little bit over, but let's maybe jump into that generative AI and the AI discussion, because there's certainly a lot to that we want to touch on today. Again, going through some of the fun facts, I'll touch on a couple of these. 378 million will use AI tools in 2025. Wow, that's a big leap. We're certainly seeing that in the market. That's certainly going up dramatically. 78% of organizations use AI, up from 55%, and 92% of students use generative AI now. Again, something we're seeing a lot in the education market, and the teachers and people having to really change how they're doing teaching courses or teaching lessons when you're having answers to reports coming up in minutes of obviously presenting that. One of the things I did want to touch on, it can be a little bit overwhelming. I guess like we said at the outset, we don't want to veer people away from using AI. This is not hopefully not a negative presentation, just all about the bad. So I did want to touch on, it is a massive wave of AI tools. At the moment, we're expecting by the end of 2025 to have over 10,000 AI tools in the market. In Australia, this is something we just found out recently last week, actually, in a presentation from Microsoft. Over 1,000 new AI startups have launched in Australia. So this is not products. This is brand new companies in Australia that are generating AI technology. But the two down the bottom there are the ones that we really, I guess, see a lot of. And when we're talking to boards and when we're talking to executives that we're talking a lot about is in Australia, 84%, and this again comes from a Microsoft survey, 84% of employees in Australia are already using generative AI. And maybe 62% of AI leadership isn't in the IT department. So if you think you're setting up some rules and regulations in your IT department to protect you, most of this is actually being led outside of your IT department, and the IT department often, in a lot of cases, don't even know what's happening when it comes to use of AI because they're using cloud-based environments and entering your data in there. like hopefully a lot of your policies and a lot of your tools, you've got stuff in place around educating your staff and working with them on what can go out and what can't go out. And a lot of the ways we're talking about, and we'll touch on this in a second, is really around setting some decent guardrails to help your staff actually understand what they should be doing and what they shouldn't be doing. But not having a discussion or not having a policy is certainly not going to be helping you, because people are already using this right now. And I know from a legal sense, yeah, there is a lot that legal has to catch up with in regards to AI. So maybe, Paul, you want to touch on some of that?
Yeah, so look, the law and AI are really, the law's in a losing area in the race. And I've put up, I always like to pick on the lawyers because I'm one of them, I can. And look, we are terrible for this in the sense that lawyers have been using AI and not checking their work so much. And you'd think that after the first headline came out, you'd probably check yourself before you continue to do this, but it is just constantly happening. But one really important thing for you to remember if you are using AI in your business is that you may not own the output of what the AI has created. So unless you contractually tighten things up, there's no copyright, there's no intellectual property in a computer-generated output in Australia. There's some cases that say that, which is a different position to what it is in China, where they've said that AI outputs can be owned. And if we had more time, I'd explain to you why that is. But just be careful about trying to retain ownership of anything that AI has created. There's also an issue that AI that is trained on material that is copyright is in fact breaching that copyright material. And we're seeing a bunch of cases happening, particularly in the US, about that. Be wary of AI bias, because we are likely to see, particularly if you are using it for automated decision-making, like checking CVs and shortlisting. Remember that AI is predominantly trained on material that is on the internet, which is white, male, and frighteningly right-wing generally, which is the general tenor of the internet. And so because of that, it may preference candidates, in the HR example, who have anglicized names, who are male, who describe themselves in certain ways, which might not align with your company's cultural values, or it might not align with equal opportunity and discrimination laws. Ultimately, the key thing to remember with all of this is that you cannot outsource your responsibilities to AI. Whatever comes out, you need to check it, and you need to be comfortable with what is put out there. That's not to say you shouldn't use it. You absolutely should be using AI. If you aren't, you're going to fall behind the competition. But you need to use it tactically. You need to make sure that you are using it for the right purposes and that you understand its limitations, because often AI looks more impressive than it actually is.
Yeah, really interesting. I think we saw this in the States with some of the test cases around using chatbots, and there's one that I remember, which was a car company that used an AI chatbot, and we had someone come in to try and basically buy a car and managed to weasel the way through and get the AI to tell the customer that they could buy a car for $1, basically, in the end, is the way it worked out. And obviously they didn't honor that agreement, because that was who would sell a car for $1, went to court, and the courts basically found that the AI chatbot was effectively, in the States, classed as a person representing the organization, and therefore they had to actually honor that claim. Now, obviously, that's all going to be tested in Australia and see how that comes through. But yeah, obviously, we do want to use it, but we want to, as I said, have some of the guardrails, use the right things, really think it through. And again, if you're not having these conversations at executive or board level, that's definitely something you need to be doing now, and start working through these things and having those tough conversations and kind of understanding where you sit on the matter. I didn't want to have this as a whole heap of negative slides, so we are getting pretty close to the end. I did want to touch on maybe some things that you can do to try and tackle this. So obviously, as we go through this, Paul, feel free to jump in and add your thoughts, because obviously you've got your flavour of these as well. I think one of the main things from my point of view is really get educated. So, go to more sessions like these, do your own research, and obviously partner with people where it makes sense to help get that understanding and that support around whether it's AI, or are you doing the right things with cyber, or are you doing the right things with privacy. try and learn as much as you can, because being ignorant of the law is obviously no excuse. And so really understand what you're trying to do. It's not easy. And we understand that as well. Like we've got people dedicated to running full-time jobs of just doing cyber or just doing AI conversations. So, but certainly I go and talk to boards often, and certainly executive teams around privacy, around cyber threats, around things. So you can come up with ways and thoughts around discussions and starting it off. And that's kind of that next point. Don't let it just sit in the background and have this presentation and go, oh, wow, this is really bad. What are we going to do? Actually discuss it in the executive groups and then the boards. Bring in facilitators to help guide the conversation and try and get an understanding of where you sit, because your level of risk may be different from the person next to you, may be different from a competitor or whatever else. But work it through in your environments and actually allow that time to happen. Makes a big difference when we go and talk to customers. The customers that have kind of put it on the back burner and just ignored it, it's running rampant. And then those that actually talk it through, at least then as that you're doing something, you can, if you do have to bring in a pool to come and help you out after a breach, at least you've got some thoughts and you've documented that stuff. It makes that process a lot easier. The other thing that we'd recommend is improve your governance. Know your data, understand the guidance and the policy to help your team understand what to do, because it's not just one person in a company, whether you're a 5-person company or a 1,000-seat company. You need to have some level of understanding and being able to provide that to all your staff so they understand what all these decisions you've had with executives and boards. Make sure that gets rolled out through having good understanding of what your policies are. Present that to the team. Understanding what you have in your data. Quite often when we're talking to customers, they don't even understand where their data is or where it's being stored or where it's gone to. So how are you going to shape and form what you want to do with it and to protect it if you don't know where it is? And then take it simple, get some guardrails. As I said, one of the things that we don't like to see is if you have no conversation, your team are using AI, your team are doing things that are probably not in line with your values or not in line with what you're doing. So actually having the conversation and having the guardrails in place. So, hey, maybe we don't use all different forms of AI. We'll pick a form of AI that we can control. So in our case, quite often we recommend Microsoft Copilot. Not necessarily that it's the best. It's got each of them are doing different things, but at least then you've got more control you can put in place around Copilot, for instance. So you can put them into a safer space to test out and try AI as opposed to just giving it over and hoping for the best. And really, as I said, don't see this as too much of a threat, because as everything we've talked about can be pretty scary, but try and turn it into opportunities. Every threat is an opportunity in some way, shape or form. Leveraging AI and understanding, your cyber governance. One of the things that we do when we talk to customers, we have to get audited for ISO accreditation for information security. And we also every year do a essential aid audit on ourselves, being maturity level 3. But we go and present that to clients and say, this is why you would want to use us. You can absolutely do the same thing.
Well, I echo everything that you've just said. I think that the biggest one there is you can't assume people aren't using it just because you haven't got a policy in place. Assume that everyone's using it, and for that reason, I would be looking at training not just the board, not just the exec level, but you need to train everyone. You need to get everyone in the room talking about what is positive AI usage, what are the risks, and how can we leverage this in our business.
Yeah, and one of the things we do, so this is some of the stuff more tangibly that we have done. Again, if you're going down the path of 365 as far as using Copilot, but I guess one of the best things about AI that we've seen in talking to businesses is also one of the worst things, is able to surface information really quickly. Now, if that information is perfect all the time and all the information you're gathering it from is perfect all the time, this wouldn't be a problem. But unfortunately, looking over the internet, there is many different views and thoughts. And so obviously it has to collate that. Even inside your organization, how many different versions of your travel policy do you have? Do you have 12 different versions? So if someone uses Copilot today on your environment, is that going to pull out the right version of the training policy or the travel policy and give them the right answer? Or is it going to give them spurious data? Or is it going to hallucinate and give you completely the wrong thing and say, yes, you've got 45 days of leave every year? So you need to do a lot of work inside your environment before you throw out the open AI or the AI discussion. And so one of the things that we're recommending to clients is doing that security readiness assessment before you start kicking in and allowing everyone to do it. And so one of the products that we came out with is a Copilot security readiness assessment. So what this kind of does is it takes it into that next level and gives you a report saying, You remember those things you shared in SharePoint 20 years ago, or something in Teams you link to that automatically provides the end user access to this document? How many of those have you reviewed? And so this goes back and does a lot of those reviews inside your organization, inside your Microsoft 365 environment that changes every other week. So this is a tangible way that if you are going down the path of using AI, maybe this is something that you could do, and you could obviously reach out to us to help with some of those things. The other thing in closing, because we've only got a couple of minutes left, is also from a security standpoint. I'm not going to go through this very big slide. You can obviously reach out for more detail. Our managed services definitely look at trying to protect clients. We align ours a lot to the Essential 8, that maturity level, so that it's an Australian government standard, what they're recommending for all businesses. Certainly what we're hearing being more enforced as we go forward, as opposed to just recommended. And so we really start with that. So as you can see in the picture, the main threat areas that people are trying to go after is either the people, the infrastructure, or software, or apps. And so we put in protections in place, and you pick and choose which things makes most sense to you within our framework to get that tackled. So again, didn't want to make this a big sales pitch, but that's certainly some of the things that we could recommend that you should do going forward to at least start tackling this. And again, having those conversations, getting someone like a Paul or myself out to, if you're starting those conversations and you need help with that starting point, certainly something I've done a lot of and continue to be happy to do. Ben, is there anything else in the questions, or?
Not at this stage in time, actually. I think we've answered all the questions that have come in. So again, conscious of everyone's time. So quickly, but very importantly, thank you, Paul. Thank you, Brett. Really informative discussion there. And thank you, everyone, for watching, for being such an engaged audience today, and for being able to pass on all those very important questions to Paul as well. Paul, again, I appreciate your insights from your perspectives on the current landscape as well. Just quickly, by all means, please stay in touch with us. We look forward to hosting some further webinars in the future and some other events. But in the meantime, sincere thank you once again to our two presenters today. And we look forward to keeping in touch with you all very soon.
Thanks so much, everyone.
Awesome. Thank you.
Cool. Thank you, Paul. Thank you, Brett.